SJC-11385, Commonwealth versus Holley.
Good morning, Your Honors. May it please the Court?
Could you just wait for a second?
Yeah, might we wait till everybody gets settled? Okay, Mr. Mirsky.
Good morning, Your Honors. May it please the Court? I'm Attorney David Mirsky, representing Jermaine Holley, the defendant appellant. Seated here is my partner, Attorney Joanne Petito, who would be filing an appearance, who has been involved in this matter with me. The first issue I'd like to discuss is really it's an overwhelming fundamental issue that this court already decided in Commonwealth versus Pisano, but the Commonwealth here, the District Attorney's Office here, has challenged basically challenged the case, which seemed to me to be very clear. Commonwealth versus Pisano says unauthorized police officers are not, police investigators are not allowed in the grand jury.
I don't think, in fairness to the district attorney, that she's challenging whether that should happen or whether that should continue to be the law. I think she's challenging the consequence, because in Pisano, the case had not been tried, and in here it had been tried.
Well, Your Honor, actually, I would disagree. I think they're challenging the whole concept because...
Okay, well, I guess we'll find out. We don't need to... We'll,
because
Ms. Stern
Pisano,
can speak for herself. But let's go to this. What, I mean...
Well, maybe, Your Honor...
Is this... We have a whole set of cases, many cases involving public trial, which is similar in that there is a right to a public trial, and if there is an objection that is done and it's overruled and the judge has an opportunity before trial or during trial to fix it, then you will get a new trial because it's a structural error. And this arguably would be a structural error too, but in those cases, in LaChance, we said, well, when there is no objection, then we do an analysis under an effective assistance of counsel and require prejudice. So why should we not do that here? And if we do that, what prejudice can you show? Well,
first of all, Your Honor, the right is not, those issues are not related. This is the grand jury. The public trial issue involved cases of jury selection where the public was kept out of jury selection, which experienced counsel and defendants in many cases would have inherently valid reasons to keep the public out of jury selection. However, there is no possible benefit and actually a complete violation of the right to a grand jury indictment to have the investigating police officers present during the testimony of witnesses, especially significant fact witnesses during grand jury proceedings.
Given, but what's the prejudice, given that it could have been re-indicted?
The prejudice is that the process of the grand jury, first of all, this court stated in Pisano that the essential characteristics would be broken down by having the presence of police officers in the grand jury, and this court found that, and I agree with that. And I'm asking the court to stick with it. And the reason is that, and this case also, I didn't get any kind of a hearing with the trial judge who did the motion for new trial. He didn't even have us in to talk even about whether there should be an evidentiary hearing. He didn't bring in the prosecutor.
Excuse me, counsel, I'm sorry to interrupt you, but the two questions that have been asked are assuming all of this. And what we're trying to get at since we're probably in an ineffective assistance of counsel situation because of the waiver issues. What we're trying to get at is whether error was likely to have influenced the jury. That's what the questions are trying to get to.
Well, it's the very process, it's the Article 12 right to a grand jury indictment. The process is supposed to be, the process is not the way it was used here. And if you, I asked the court, which I know the court is doing under 33E, to read every page that was submitted of the grand jury testimony.
Is your argument, isn't your best argument that if then Justice Liakos is correct, that it renders the indictment void, then the conviction is void, and you don't get to ineffective assistance? Is that what you're trying to say?
Yeah, it's void because Pisano says that the presence of unauthorized police and investigators in the grand jury will void an indictment. Well, that does not mean the language that the Commonwealth used as if it was a contract or something. What it means is, as a matter of natural consequence, in a grand jury process, you have witness testimony in the grand jury, and then an indictment would follow based on that. So when the court says it will void the indictment, it will void that indictment that comes. So the indictment is void.
Well, let's discuss that, because let's imagine a situation which I know you contend did not happen here, and I'm not suggesting did happen here, but imagine a case in which a defense counsel knows all about a Pisano violation and does make a strategic decision, which I understand you say did not happen here, that the Commonwealth's case actually is not so strong right now. I'd much rather take this case to trial now as opposed to moving for a new trial under Pisano and giving the Commonwealth a second chance to strengthen its case before the grand jury. So I know I have a Pisano motion that I could win, but I've decided not to bring it because I think I can win a trial now, and I'm not so sure I could win a trial if the Commonwealth were to improve their case.
Well,
If you're right, if it's void, the defense lawyer would not have, I mean, what happens in that situation if it's void? So he makes the strategic call to go ahead and...
Can't do it.
So
However, Your Honor, if,
dismissal with prejudice?
yes.
No. Why with prejudice? Just the indictment gets dismissed and you can re-indict.
No, first of all, if the court can decide that you could waive the fundamental right, a court can decide that, this court can decide that, and then you would need the testimony of this trial counsel who said she did not have a strategic reason in her affidavit, who the trial judge and the motion judge did not disbelieve and did not hear and did not allow even any kind of presentation, that she said that she did not know the law, and
Right,
that's why.
I understand, I mean, the separate issue as to whether Judge Kane had a factual basis for finding that this was a strategic decision. Put that aside.
Okay.
But if it's void, I don't quite know what happens when the defense counsel does make a strategic decision to proceed, because you're saying it's void. You're saying it doesn't...
I am saying it's void, Your Honor. That's why there's a separate argument. I have made the other argument that if this court's going to decide that you can waive the right strategically, that you have to have a hearing and find out if defendant has presented evidence not disbelieved by counsel that there was no strategic reason, and actually it was professional incompetence admitted by trial counsel, that you can't, that this trial motion judge could not deny the motion this way. Now, but I'm saying something different about Article 12 and the right of the grand jury indictment. I am saying the grand jury process is a different process. In this case, and I was trying to say this before, if you read all the grand jury transcripts, which are under, I filed as impounded, but I don't believe the motion to impound's been allowed yet.
What's worse, a Pisano error or an Odell error?
I don't know, Your Honor.
So
I'm not. I mean, I'm not talking about Odell, so.
Right, well, I am now. So if we have Pisano error, there's a police officer in the grand jury, which is wrong. If we had an Odell error where the government misrepresented evidence and presented in bad faith evidence before a grand jury, isn't the analysis in Odell whether or not there should be some type of prejudice?
Your Honor, I am, the right that I am here arguing under, that would call for this being dismissed with prejudice is the Article 12 right to a grand jury indictment. The process is not the way it was handled here. It is not a tool of the prosecutor to make a stronger case. It's supposed to be an atmosphere free from outside influence where the prosecutor is supposed to act as an officer of the court and present evidence to a grand jury, which is not supposed to be pressured. And it is not a place where you bring in this case, 2 investigating police officers, sometimes on particular witnesses who are important, and have them there. And we don't know what happened, but we do know that one witness definitely testified freely in the grand jury with 2 investigating police officers announced to be sitting there and did not want to do that in the trial. And whether one would find in retrospect that you believe that the evidence was correct or not correct, it doesn't matter. It's the procedure. That's not the procedure of a democracy. We're supposed to have the grand jury indictment. It's supposed to be a protection of defendants. It's an Article 12 right. It's not a tool of the prosecutor. It's supposed to be pristine. And another thing about it in terms of prejudice and showing prejudice, things go on in a courtroom. Things have gone on in this courtroom, okay? Things go on that no one will know from the transcript. And there's people present, and we don't know how many witnesses were present at various times. The case law says you're not supposed to have a series of witnesses shown to show how strong the case is to each witness to make them feel pressure. We don't know when the witnesses were there. We would need cameras in this grand jury room. We would need recordings, and we would need the defendant present. We would need his counsel present in order to protect his rights in that situation. And what goes on in the grand jury transcript, what comes out on the paper is used later in the trial and permeates the case. And people's statements, people are held to those statements. In this case, the prosecutor even used an argument, in his closing argument, a statement in the grand jury telling that, stating to the jury that you can only use this for credibility. But he gave the facts so the jury would know that in the grand jury, this particular witness, Mr. Gendrolis, had said a different height for the person that he was identifying. In the grand jury, he said the person was about the prosecutor's height. This is the person in the hallway that was supposed to be, that there's a dispute about. The witness at trial said the person was 5'7", and it came out in the grand jury the person was that the prosecutor was about 6'3", and this person said it differently in the grand jury. Now the prosecutor put that in before the jury, and they're trying to say that's my client. Now this particular witness at trial was shown my client and said that he could not, that was not somebody that he knew that he had seen. He did not identify that person. Okay, and the Commonwealth did not tell my client, stand up, let's figure out if this person is that person, if they're the same height or anything like that. No, they had it on paper from the grand jury with their police officer, 1 or 2, I don't know at that point, present, and we don't know how people felt, and I would need to depose every single witness that came in front of the grand jury to know how people react with police officers present. We wouldn't put...
Is that Mr. Torres you're talking about? Is that
Excuse me?
Is that the witness's name? Torres?
Gendrolis, Thomas Gendrolis.
Oh, okay. Who's the witness whose testimony came in substantively? Grand jury testimony came.
Jose Torres.
Torres.
yeah.
But he's not the one who identified, oh, well, he wasn't
No,
there.
that's a different
Okay.
issue. Should I move on to a different issue? Yes.
Probably, yeah.
Okay.
If you would discuss the footprint, the testimony at trial was that this footprint appears to be in the category of shoes, so it's consistent, or are you saying that this witness said, no, this was the shoe we found in the defendant's?
They were saying that this witness, Monty Gilardi, was saying that you could identify somebody, that sometimes you can identify a shoe, and I think the word was, I think it was, you could make a conclusive identification that this was the exclusive shoe, sometimes based on an anomaly.
Okay,
but
did he say, I now show you exhibit whatever, this is the shoe, is the footprint, did that come from this shoe? Do we have any testimony that said it was that shoe?
That's what the
which left
prosecutor
that footprint?
argued. That's how he argued it.
It was argued not that this is the kind of shoe, this is an Adidas. By the way, was the shoe an Adidas A3 decade?
That's
shoe?
how I that's how I took it, Your Honor. That's how I took
Their
the argument.
testimony as to the type of shoe, did it say Adidas A3 decade on it? Did someone say?
Oh, there was testimony that the pattern, from a prior witness, that the pattern fit patterns of an Adidas A3. But that's not.
Did anybody say that the shoes they found were indeed Adidas A3 decade shoes?
I believe that. I think that the way that they that the way this identification, the issue that I've raised is about whether the anomaly, which they're saying is, which the Commonwealth argued was possibly gum or a gum-like substance on the shoe, could conclusively identify this shoe as coming exclusively from that. The print came exclusively from that particular shoe. Okay, which is, and also the prosecutor used the words in discussing what he called the expert evidence from his shoe print footwear people, that the print was lifted like a fingerprint. So to give the jury the impression they're going to see something like a fingerprint, and this is actually junk science, because what Mr. Gilardi testified was that it's rarely done with a single, that you sometimes can make this identification based on an anomaly like this, a piece of some kind of gummy-like substance, but it's rarely done. And what I'm saying is that that's not a scientific process or procedure that should be presented to any jury as science or as any kind of forensic evidence of any kind of extra value. I mean, they can look at it and make their own determination, but there's going to be lots of shoes with lots of things on them, and to say that something is conclusive like a fingerprint, even though now we've heard that fingerprints aren't necessarily as reliable as what we used to think, but that's a different issue. We certainly don't have anything scientific to say that particular shoe, we're trying to say that particular shoe in blood in the crime scene puts this client here, this defendant here, conclusively, and with science, and it's not science, and not under Lanigan.
Can I ask you just what was the evidence that Mr. Bomberg related confidential information about your client to the prosecutor?
Yes. What I'm saying is that the Assistant District Attorney, Bomberg, who was hired to do homicide cases and had worked with the Assistant District Attorney in this case, who prosecuted this case, never disclosed. He represented my client. He knew, presumably, what you know as a defense attorney about your client, lots of confidential information. and he never disclosed, he never was presented, he never told my client what he said or what his body language was or what he did, what went on in the room when he was talking about the case. And what I'm saying is that you can draw the inference that Mr. Bomberg did not say definitely to the assistant district attorney who prosecuted this case, he did not say, this can't possibly be the guy. He said something, he did something to communicate, this is okay, yeah, it's okay. And until the right to counsel is more important than that, than allowing prosecutor to do that. We need to, the rule that was applying at the time and the way the law, the right to counsel should operate is that this defendant should be told by Mr. Bomberg what he said, what he was asked, what he said, what he knew, what thoughts were going on, what he was communicating to the prosecution in this case before they went forward with charging him and with an extraordinarily heinous crime.
Okay, thank you.
Thank you.
Ms. Stern, good morning.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. As a preliminary matter, the Commonwealth is not challenging any of the holdings of Commonwealth versus Pisano.
Along those lines, let's just assume that, without getting into it at this particular moment, that it's voidable and not void. Assume that there's ineffective assistance of counsel for the purposes of my question. And then Mr. Torres testifies, he's a 404B prior bad acts witness.
Yes.
And his testimony comes in because the judge finds that he was feigning. And so his grand jury testimony comes in.
Yes, Your Honor.
The two police officers are right in there during the grand jury testimony. And why isn't that enough to show that there might have been prejudice?
Well, I think in this circumstance, the issue of Mr. Torres' testimony coming in was very extensively litigated. There was no reference to Pisano, but there were multiple voir dires. Defense counsel questioned him on whether there were police officers present. He did not recall there being police officers present. He affirmed repeatedly that he told the truth to the grand jury, even though he was not willing to claim to remember any of it, and said he didn't identify the defendant. So I think in light of, there was a lot of concern about, obviously, when you admit grand jury testimony substantively, there was a lot of investigation, and the judge talks about, he talked to, I think, an officer who talked to his mother, investigated, did he have mental health issues, did he have drug issues, determined that he was very transparently feigning loss of memory because he did not want to be a snitch. And the grand jury was 2007, the trial was 2011. A lot of things can happen in that time. And the grand jury testimony, I think the judge found essentially appropriately detailed, sort of reasonable recollections. So I think in light of all of those factors, and again, the fact that defense counsel was clearly aware of the idea that this witness might have been influenced by either might have been, did the prosecutor bring up the defendant's name first, or did you, those sort of questions, that angle was investigated, even though it was not specifically with reference to whether there had been officers in the grand jury. And I think defense counsel showed a strong sort of familiarity with the grand jury minutes that suggests that whether or not she was aware of the Pisano case, she was aware of the entirety of the circumstances in which the testimony had been presented to the grand jury.
Did she ask the question whether anybody else was there?
Yes, I believe she asked if there were police officers. It's not clear from the context of the testimony whether he is describing the grand jury or being in a room with the prosecutor, because his answers are a little bit vague. That appears to me to be clearly what she's trying to get at. But he says it was just him, his mother, and the prosecutor the first time he talked to the police. I don't know that that's, or the first time he mentioned this knife incident. I don't know that that's true, but that was how he represented it at the grand jury, that, nobody else there, never talked before, et cetera.
If you, Justice Lowy's question assumed that the indictment, the presence of the police officers made it voidable. But if Pisano says it's void. Does that make a difference in terms of whether you apply a what you do with the ineffective assistance?
I think that a void indictment would be a thing that would be difficult for anybody to work around. I do not think that we are in that universe.
So Pisano, so we should disagree with Pisano when it says that.
I think that when Pisano says will void, for the reasons I explained in my brief and for an additional reason, I think that it means that the defendant is entitled to have it made void in the future, not that it is void ab initio, that it is voidable. Partly because, as I say, Pisano discusses, what do we do now? Do we need to show prejudice? If it's void ab initio, it doesn't matter if there's prejudice. We don't need to ask if there's prejudice. It's already gone. Also, I did not raise in my brief, but I mentioned that I would be referencing the case to my brother yesterday, but Leibowitz petitioner, which is mentioned in Pisano, I somehow overlooked before, deals with a case in which there were police officers in the grand jury. I think all of the witnesses were in the grand jury at once. Counsel and the defendant did not know until after the trial and then raised it, and they said the question is, can he get relief now? No, you have to raise this before trial. Now, that was 1920, and a number of things have changed, but Pisano is a very conservative case. It concludes by quoting Harris from 1919 saying, we think it wise to conclude to follow the well-settled methods of procedure which were adopted at and have been continued since the settlement of this Commonwealth. I think if in 1920 it was voidable rather than void, then it was at the time of Pisano, and it still is.
So what's the remedy for Pisano error?
Just at the motion of the defendant, dismissal with no further showing of prejudice. So I think that is a remedy that, as a general circumstance, would deter a person who was aware of it of risking it. I think it's only either strategy, for whatever reason it was not raised in this case, it could have been.
I'm sorry to interrupt, but then leads us, of course, to ineffective assistance. Now.
Well, I think that there is a dispute of fact about whether the judge found, defense counsel says appellate counsel drew her attention to the Pisano decision, and having reviewed the grand jury transcript, she thinks she should have filed a motion to dismiss. She does not say why. The judge found that she made a reasonable strategic decision. As I argued in my brief, she does not say she was not aware of Pisano. She leaves that open. Whether that's a fault of drafting or intentional, I don't know. I argued that could support his conclusion that there could have been a reasonable strategic decision. If, in fact, she did not know, I think that still does not mean that the defendant was deprived of otherwise available substantial ground of defense. Judge Dupuy, in her decision in Woolham, seems to question whether this was as commonly known as perhaps it should have been among capable attorneys in general, given that there are two of these cases, neither of which anybody raised it prior to the trials. In any event, I think that there's some reason to think, from the context of the transcript, that this is not a case, or from the context of the record, this is not a case the defendant was looking to pursue a delaying defense. He did not want he opposed an extension of time for an interlocutory appeal. It would make sense that would be the case because while, as I argue in my brief, this was a composite case, there were 36 witnesses. Almost everything came from multiple witnesses. There was no single crucial witness. The forensic witnesses were unlikely to deteriorate with time, and they were among the strongest parts of the Commonwealth's case. And the defense, by contrast, made use of a number of witnesses' lay testimony in an attempt to try to, for third-party culprit for other purposes, that essentially a delay in this case might very well have caused the defendant's defense to deteriorate more than it would cause the Commonwealth's case to deteriorate, and that there's no, insofar as the benefits of delay are always a little sort of ambiguous to determine in hindsight, I think that in this particular case, there would be reason to think that would not necessarily benefit her client, particularly if he simply did not want to be held pre-trial for much longer.
Now here, there at least was a reference in the grand jury transcript to the presence of the police officers.
Yes.
Do we know whether that's the norm? I mean,
well, I can.
How you say we have two cases. How do you know that this has only been done twice in your office?
I know that there were these two cases, which I think, as you can see from the record, there was a new administration, there was a new cold case unit, there was a new grand jury investigation to solve these cases. I know that appeals wrote a memo sometime in 2007, and to my understanding, this has not happened since. I don't know if the issue was flagged by the prosecutor himself or if somebody else raised it, but I know that it was discussed, and I have not reviewed all of the grand jury transcripts for the past 10
But of
years,
course,
but I
that,
would be,
that assumes it'll be found in the grand jury transcript.
well, I think the fact that it was I think it was declared by the prosecutor. This was not at all under the radar.
No,
This-
I understand that. I understand that here, but I mean, but
Oh.
my concern, well, I mean, I'm concerned that the culture of your office and the training of your office permits this to happen, period, or did in the past. But apart from that, I'm also concerned is that I don't know now whether this is happening and no one is making a reference before you start the testimony as to who's present in the grand jury room. I mean, how do we know that this is not happening routinely and not being mentioned and would be unknown to everybody?
Well, I think that the very fact that we are here suggests that this is not something, I mean, by definition, in any case, you can't know what isn't recorded in the grand jury. But I think that the very fact that this is on the record, it was up front. This was not a,
Okay, would it matter here, of course, the defense attorney was able to read the grand jury transcript and see it, and at least had the opportunity to see it. Would it matter if it was not included in the grand jury transcript and therefore defense counsel would have had no knowledge that it happened?
well, I would say that in Leibowitz, that did not matter. Again, 1920 was a long time ago. But I think that the issue of, and again, in Mechanic too, I think, which is again not, that's federal law, that's different, but these are cases in which people did not know until later. I think that the fact of the intervening jury trial really is a crucial factor here. But I think that there's no, I mean, we have a case here where this shouldn't have happened, but the very fact that something that legally should not have happened was declared openly in front of the grand jury. In fact, I don't see that that should in any way raise a concern that things that are not being declared are happening in front of the grand jury any more than in any other case.
Let me rephrase it. Is it your view that there can ever be prejudice?
Oh, I think that, for example, many cases have reluctant witnesses. I think if you get one witness who says either on the record or to a defense attorney, I really didn't mean that at the grand jury, I felt pressured, and I'm sure there are people who would love to say that even if they told the truth, you could absolutely go from there with an inquiry. I think that there are certainly circumstances in which there would be evidence or a hint of evidence that somebody really had felt coerced at that stage, did not want to stand by that testimony. It would provide an avenue for them to avoid being a snitch. In this case, Torres was very clear he told the truth to the grand jury. I think that it would, and one of these cases, I don't know if it was Pisano, specifically mentions it would be hard to show prejudice before the trial. But so you have the fact that you have a jury conviction beyond a reasonable doubt, and you have the opportunity for the witnesses to change their testimony, to talk to somebody, to say anything about how this was affected by, how their testimony was affected in these circumstances. I think that people, I think I've seen a number of cases where, even in circumstances where it's fairly clearly specious, somebody's like, nope, none of that happened. Everybody who says that I said this is just making this up. I'm completely like, I see nothing, I do nothing. I never implicated anybody, even if you have me on tape. And I think that it's not at all unlikely that there would be a circumstance in which a witness in one of these cases would be willing to say that and would be willing to say that before the trial. And in that case, you would absolutely have to conduct a serious prejudice analysis, and you would be in a very complicated circumstance. So I think it's unshowable from a sort of platonic intellectual exercise before the trial. But once you start, I think that there are certainly you could imagine a number of circumstances in which the issue could even raise itself in terms of.
Before the trial, you just dismiss it.
Oh, no, absolutely. But so you don't need to show prejudice. But if you did need to show prejudice, one of the reasons you don't need to show prejudice is that it's harder before you involve actual people.
So you're not saying that the mere fact that a petty jury convicted means no prejudice?
No, I think it's irrelevant. It means there was sufficient evidence, but it's not dispositive in the way it would be in the federal courts.
And you're not saying that the mere fact that the Commonwealth could go back and probably get another grand jury to indict shows that there's no prejudice?
No, those are relevant factors, certainly, but I think that ultimately, I think at this juncture, in this circumstance, is by the time the defendant has a very strong remedy before trial. I think after trial, he has to show more. And I think in many circumstances, you could imagine situations where a defendant
Does that
could.
require an evidentiary hearing then?
Excuse me, Your Honor?
Does that require an evidentiary hearing to sort out whether or not there was prejudice as opposed to a ruling on the papers?
I think that the defendant has to essentially allege particularized prejudice. I don't think that trying to call in all of the witnesses to determine whether there was not prejudice, 10 years later when none of them have said anything about it in the interim, is necessarily a very useful truth finding.
So in this case, the proffer that defense attorney raised to show prejudice was insufficient.
Yes, I would argue that, I think the judge looked into this very carefully. He specifically requested Mr. Torres's, all of the relevant transcripts, even though the defendant did not specifically raise the issue of Mr. Torres in his motion for new trial. The judge appears to have seen it anyway. The defendant otherwise, and I believe particularly in the motion for new trial, but also in the brief, just keeps quoting Pisano about the risk of prejudice. But I think that at this juncture, with closed courtrooms, it's arguably considerably harder to show prejudice even after on a waived issue, simply by the nature of the thing. But they're still required because at a certain juncture, standards of review change, and we've had a exhaustively litigated by both sides 36-witness trial, and it's been nearly 10 years since the indictments and 11 or 12 since the murder. And
Sneakers.
There were many different witnesses on the sneakers, and they all said different parts of the puzzle, and Gilardi said, I believe fairly clearly, that if he had a shoe, he would want more than one anomaly to make a determination, but maybe you could make a determination with one anomaly. He didn't say anything about whether, he never saw the shoe. He retired before they got the shoe. He makes no assertion that the shoe matches. There's testimony it's the same size. There's testimony of another witness, it could fit the footprint. Judge Kane says nobody's testifying about the anomaly. The jury can see that for themselves. They can decide if that matches. The prosecutor argues in his closing that the jury should conclude that it matches because he's entitled to say, you see the pictures. I am arguing from the evidence that you can draw your own conclusions. And the judge left that in the province of the jury, and it was. But there was no expert testimony that this was the shoe.
I'm sorry, let's focus on that.
Yes.
Would an expert here be allowed to opine that it was a match?
Probably not, but nobody did.
So if an expert could not opine, how could the prosecutor argue it?
Well, I don't know that he used the word match, which is dangerous. He can say, you see that image on the footprint that looks like an anomaly, you see the shoe with the gum on it. I think you could conclude that.
It's consistent with, but
Yeah.
that's different from saying that's the shoe.
That could be, but,
Was there any objection to that with regard to the closing?
well, again, I would need to double check what was actually said about in the closing, but there were several objections. I don't believe that was one of them. One of them was that he said, there was an objection that he'd said that the shoes were in the victim's blood. And Judge Kane ultimately agreed that that was a reasonable inference from the evidence. There was blood on the shoes, there were footprints in the blood, it was her blood. You can argue that. And there was an argument about the blood next to the light switch, which the judge, on rereading, I don't think that there necessarily actually was any error, but the judge gave a curative instruction anyway.
I thought it was inconclusive,
Oh, the
blood near the light switch.
oh, absolutely, yes.
So Judge Kane, being very careful before the opening statement, says, no inconclusive evidence gets mentioned, I believe, and then inconclusive evidence gets mentioned concerning the light switch.
In that sense, I did not clearly understand the defendant to be raising that, so I have not reread that as carefully as I should have. But I think that the issue, essentially the argument made was, we know that the defendant's excluded from the light switch, I believe. So I think the prosecutor was concerned there would be an argument about, well, one of the other samples must be the real killer. And I think he was trying to explain that if those are real DNA, they're not, they could be somebody plausible who definitely was not the killer. That's not third-party evidence. He points out that only the Commonwealth's expert even found those samples. So in that sense, I mean, he really I think he's trying to get at the angle of it could be anybody, rather than to argue that that obviously he's not saying it implicates the defendant. We know it's not the defendant. I think he was trying to address a concern that it could be used against the Commonwealth, which,
But, I mean, didn't the judge give a curative instruction right there?
yeah. So in any event, the judge instructed on that at the request of the defense attorney.
With regard to the DNA that was found from the vaginal and anorectal swabs, was there a minor profile, or was this the only profile?
I do not recall any testimony about a minor profile, so.
This is obviously in the sperm fraction, of course.
Yes,
And these were sperm cells.
I believe so, yes. And,
So these were the only sperm cells found in the vagina or in the rectum.
Wasn't there testimony that what was by the light switch, that the sperm cells, that the profile in the sperm cells was inconsistent with with the DNA on the?
yes, Your Honor, I don't think it was contested that the defendant's DNA was not on the light switch. I think that the prosecutor, again, was concerned, given that it was not the defendant, is somebody going to say, this must be the third-party culprit who should have been charged instead, and was attempting to explain away the Commonwealth's inconclusive evidence, which the defendant contested actually had any value in the first place. I think that the Commonwealth's case was fine with there being nobody's identifiable DNA by the light switch. But yes, Your Honor, if there are no further questions,
Okay,
Commonwealth rests on its brief.
Thank you.